heard and maybe read about protection officers, the problem which came up with protection officers, DIR, Aishwarya told you, not being filed on time, matters remain pending, and then there were no permanently appointed protection officer for almost 10 years. Now there is another name which will come, another nomenclature, another entity, that is service providers in DV Act. So please tell everyone what is the concept of a service provider.
So basically, Section 10 of the Act lays down the functions and duties of service providers. So service providers are defined under the Act as any voluntary association registered under the Societies Registration Act of 1860 or any company that is registered under Companies Act of 1956, which aims to protect the rights of a woman lawfully by providing legal aid, medical, financial or any other assistance. Further moving to the duties and functions of police officers and magistrate. So section 5 of this act lays down the duties and functions of magistrate or police officers, and it states that when a police officer, service provider or magistrate receives a complaint of domestic violence, an incident of domestic violence is reported to him, or he is present at the scene or of occurrence of domestic violence, then in that case they should take following steps, which include: they are required to inform the victim about her rights, to make an application for receiving relief by way of protection order, order for monetary relief, custom order, etc. They should inform the victim of the accessibility of services of the service provider. Further, the victim should be informed about the services and duties of the protection officers. And lastly, they should inform the victim about her right to free legal services under the Legal Services Authorities Act of 1987 and her right to file a complaint under section 498A of the Indian Penal Code. So moving further, if any victim of domestic violence requires a shelter home, then in that case section 6 of the act provides that the person in charge of a shelter home will provide suitable shelter to the victims of domestic violence in the shelter home. Under section 7 of the act, it lays down that if an aggrieved person requires medical assistance, then the person in charge of that medical facility will be providing such assistance to the aggrieved person.
Very nice. So as you can see, generally the concept that for redressal of a grievance, we have only a police officer to go to. So here you have seen that, okay, police is definitely there, but these victims can also have access to a protection officer or a service provider, right? Is it clear? Which sections you have just listened to so far? You listened to section 12 when you were discussing the DIRs. Section 12, Aishwarya told you about. Then you went through section 8 and 9 relating to protection officers. Section 10, she just told you about service providers. Shelter home is in section 6 and medical facilities is in section 7 of the act. Is it clear so far? Now, Rohan, is it? Rohan?
Yes, sir.
So Rohan would be covering the aspects pertaining to magistrate and what kind of relief can a victim be entitled to under the Domestic Violence Act? What different kinds of relief she is entitled to? So, Rohan, kindly go ahead and let us know the role of magistrate and the different reliefs which they are entitled to.
Yes, sir. So, firstly, I would be talking about application to magistrate. The aggrieved person or the protection officer of that locality or any other person on behalf of the aggrieved person shall make an application to the magistrate claiming one or more reliefs under the Domestic Violence Act of 2005. The application must contain all the necessary details which has been mentioned in the Act. The magistrate is responsible to fix a date of hearing which shall not extend more than 3 days from the date of receiving the application. Furthermore, the magistrate also aims to dispose of the application which is made under section 12 of the Act within a period of 60 days from the date of first hearing. Moreover, the Protection of Women from the Domestic Violence Act 2005 authorizes the magistrate to grant the following orders and reliefs. So, firstly is the monetary relief. While disposing the application of the magistrate may ask the respondent to pay monetary relief to meet the expenses incurred and the losses suffered by the aggrieved person and any child of the aggrieved person as a result of domestic violence. And such relief may include the loss of earnings of the victims, medical expenses, the loss caused due to damage or destruction of the property, and her children as required under the section of Criminal Procedure Code. The respondent must pay the monetary compensation to the victim within the stipulated, and if they fail to do so, then the magistrate may direct the employer of a or a debtor of the respondent to directly pay to the victim or deposit within the court a portion of wages, salaries, or debts. Section 22 of the Act also stipulates that respondent will be liable to pay compensation to the victim for causing any damage or injury, including the mental torture and emotional distress as directed by the magistrate. Secondly is the custody orders. Under Section 21 of the Act, when the magistrate receives an application concerning the domestic violence, he has the authority to direct the custody of any child or children to the victim of the person making an application on the behalf of the victim. Third is the protection orders. If a magistrate is satisfied that the domestic violence has taken place, then they may pass a protection order in favor of the aggrieved person to prevent the respondent from committing any acts of domestic violence or abetting any act of domestic violence. The magistrate may also prevent the respondent from contracting the aggrieved person, entering the place of employment of the aggrieved person, or causing the violence to the dependents or the relatives of the aggrieved person. The last is the residence order. Under Section 19 of the Act, if the magistrate is satisfied that the domestic violence has occurred, then the magistrate may pass a residence order restraining the respondent from disturbing the possession of the aggrieved person from the shared household, or to withdraw himself from the shared household, restraining the respondent or any of his relatives from entering the shared household, and prohibiting the respondent from repudiating his rights in the shared households. Yes.
So, there's a request coming up that the guests want to see everyone. So just once, so you can all wave at them. They want to see, they can't see each one, they are probably only seeing me. Okay, thank you. Welcome everybody who's online also. So you can mark this. What are the kind of reliefs a victim is entitled to? So like you have section 17. She has a right to a shared household. So again I'll burden you. Now we were handling a case which I quit. I left that case after High Court. I didn't take it up ahead because of some reasons. The story so far is that a person meets a lady while they are students in UK, and it's a marriage of choice. They get married, maybe say it is 1996 or 1997. They are there and they are blessed with the birth of 2 daughters, and they stay together. The husband is a very, very big industrialist, and they stay together in that company premises in a city not far off from here, and they stayed together till 2012. So that's a substantial period of time, and the girls were growing up. Suddenly there's a rift. The husband goes to US, gets a divorce in US, and starts living with somebody else, a US citizen, and who's not an Indian. The wife files a case under Domestic Violence Act against the husband, and she says, this is what I want for me, a monetary relief, this is what I want for my daughters, and this is a shared household. You just heard that word, section 17. It's a shared household. What the husband did or didn't do is a different story. I mean, he was being very miserly, and if he had not intervened and pressed hard upon him, he was not even paying anything for his 2 daughters. And it was only when that apprehension arose that the custody would go to mother, permanent custody, that he got his daughters admitted in a school in US and then paid for the fees. Otherwise, they were studying free of cost again in a school, and he was not taken care of. And all those things have now probably accumulated to 90 lakhs since 2012. Till date, he has not paid. But now the concept is of shared household. So he was fighting for the shared household, and the company also moved an intervention application that this bungalow is a company's asset. So the wife cannot live in it. So can you just let them know about the legal aspect relating to